Hey guys, so in the Manson versus Wood Gore case, there were some filings today or yesterday, I suppose, relating to evidence, particularly on the anti-slapp motions, and we'll take a look at those. If you remember, there were lots of objections interposed by all the parties to evidence, just in the hundreds, and the judge said, come on people, get together and work this out. So they have done that. That's what these filings are about. There's two filings, and one is a withdrawal of evidence by Manson, which is essentially to reduce the number of objections, not more to it than that. The second is a joint filing by the parties where they have reduced their overall objection numbers down to 18 in a handy 55-page document. So that's why I'm doing the stream. I haven't read it yet. I don't want to read it. No one should want to read it. They probably didn't want to read it while they were writing it. The judge doesn't want to read it, but she gets paid to do that, and she will. 55 pages of discussing whether evidence should come in or not. Let's look at the first one, which is the evidence withdrawn by Manson. And so you see he withdraws following evidence submitted as part of his November 15th, 2022 filing. None of the evidence affects Warner's opposition to the slap motions or anti-slap motions, as these portions of testimony exhibits were not cited or quoted in his opposition. And let's see, some of that is about being a victim, about the Groupie video, of course. And Burke, who is an attorney and was representing Manson on some of the potential criminal stuff, some of her things have been withdrawn here, including what she told Agent Langer, that she represented Manson. Yippity dip. Agent Langer said she's never not investigated any matter related to Wood. She said she didn't write the letter, didn't authorize the contents of the letter, didn't authorize her name to be used on the letter, and there's no violent crimes department, which I agree with, there isn't. That's withdrawn. Names familiar, withdrawn. During this call, Agent Langer confirmed no active criminal investigation of Warner being conducted by the FBI, withdrawn. Suspicion of how her name was used, withdrawn. Just more and more cool things withdrawn. Some of them are actually from Warner's declaration himself, about McGaffigan and about what Gore said about him. And then he says he's been the target of a fake letter purportedly from a real FBI agent that he was told to his counsel by the agent that wasn't drafted, signed, or authorized. And they had never investigated him about any matter related to Wood. That's withdrawn. Something about the swatting, withdrawn. So anyway, that stuff is out because he has withdrawn that, and then also a little bit of other stuff. So you can slow this down and read it here, or check the Manson cases who provided me with these documents. I am thankful for that, even though it hurts to have to look at things that are this long. So this first one is pretty short. And again, this evidence is not being withdrawn because of some epic conspiracy, but by an effort by the parties to reduce the amount of objections that exist prior to the judge getting to the point where she's ever going to decide on the anti-slap motions. Let's look at this handy 55-page guide to what objections still exist in this case for these motions. Joint statement. Pursuant to the court's December 1st order, the parties hereby submit this joint statement regarding objections to evidence submitted in connection with defendant's anti-slap motions. All parties' objections have been consolidated into this joint statement, and they've been consecutively numbered for your convenience and enjoyment for ease of review and discussion. And it is pretty sweet because you can see it tells who's objecting, what the stuff is, what the grounds are, and then a do you like me or do you not like me ruling over on the right, sustained or overruled. And we'll just leaf through these a little bit. This more or less it varies depending on who's making the objection, who's responding. You didn't do this. I did do it. You didn't do this. I did do it. And it just goes back and forth like that. So the first one, the first handy objection here is number 1, which is Wood's declaration, talking about meeting with other victims and discussing with them about being a survivor of domestic violence, etc. I will pause here for you to look at it on the screen, read it yourself so that you can get the full emotional impact of this potential testimony. So Manson says, hey, Wood didn't establish personal knowledge that these people were other victims or were survivors of domestic violence or had similar experiences. She doesn't even identify these people, but she relies on the truth of these statements to try and strike Warner's pleadings. That sounds pretty good. Defendants say this is an objection based on semantics, Your Honor, not substance. Wood's testimony that she met with other victims is not hearsay. She's testifying about her own attendance at a meeting on a specific date, not any out-of-court statement, which is what hearsay is. She has foundation to testify that she personally attended that meeting. Sole objection to the statement is Wood's use of the word victims. And then it gets into talking about why Wood would think that's the right word to use. Whether you believe it or not probably depends on what you already think about this case. Let's see. And they make the point at the end that they don't have to prove all their accusations that she made about Manson are true in order to prevail on the anti-slapp motion. That's not even the right form for this, which that's true. The anti-slapp motion is to test the plaintiff, which in this case is Manson, and whether he's put forth a viable case on the allegations he's made or not. That gets tested pretty early, and he has to forecast / show at least some evidence to support the necessary elements of all his claims. Objection number 2 is Manson again, objecting to part of the Wood Declaration. I've provided evidence to the FBI and the Los Angeles County Sheriff's Department in connection with the criminal investigation of Mr. Warner. Upon information and belief, those investigations are ongoing. And it's irrelevant, prejudicial, hearsay, lacks personal knowledge, and lacks foundation. So you see the grounds for Manson's objections there. One of Ms. Wood's main arguments for why the anti-slapp statute applies is that the claims at issue arise from statements in anticipation of or in connection with a criminal investigation, which are protected activity. So again, you can't try to file an anti-slapp motion on just anything. It has to relate to a category that comes under the motion. So that's Wood's responsibility to do that. If she's successful in that, then Manson has to show he has the case that can survive this motion. And he says this is just a mere vague statement, a vague connection, doesn't really connect the alleged conduct and the unidentified investigation referenced in their declaration. She doesn't even say what the investigation's about. But yet she uses those things to sweep the complaint's varied allegations into the bucket of protected activity. And also to support the strike allegations relating to the fake FBI letter bearing the forged signature of Special Agent Michelle Langer. Information based on, or testimony based on information and belief is hearsay and must be disregarded, unavailing for any purpose whatsoever. Yeah, I mean, information and belief is usually what we wrote in the complaint itself is just a mere allegation. Upon information and belief, this. Maybe you don't have full evidence of it at that point, but you think it happened. So upon information and belief. You could be wrong, right? So I kind of see what they're saying there. That's usually complaint type of language. So the bottom line is Manson says that Wood, because she participated in some investigation of Manson, any statement about Manson is now in anticipation of that, but she hasn't laid a foundation to make that connection. It's untethered testimony, has no substantive relevance. It's unduly prejudicial. It's outrageous, potentially salacious, and it should be thrown out. Defendant's position. Defendant's personal knowledge and foundation objections are frivolous. Wood clearly has personal knowledge and foundation to testify that she personally has provided evidence to both the FBI and the Los Angeles County Sheriff's Department in connection with criminal investigations. Who would know more of that than her herself? She also has foundation to testify about her state of mind, her knowledge of the criminal investigations, and belief that they are ongoing. That's relevant as to whether she engaged in outrageous conduct, which parenthetically she did not, and whether she acted with intent to inflict emotional distress, parenthetically again, she did not. And plaintiff's argument that Wood is not providing any testimony about the subject of the criminal investigation ignores the context of the rest of Wood's declaration. Why she feared being near him, etc., etc. And you can read the rest of that if you want. Due to the glazing over of my eyeballs, I cannot. And I will proceed to the exciting conclusion, which says plaintiff's objections should be overruled. Objection 3 is also Manson, who once struck from Wood's declaration A true and correct copy of the HBO documentary Phoenix Rising, parts 1 and 2, will be lodged with the court on a thumb drive as Exhibit 4. Objection grounds, hearsay, hearsay within hearsay, that's sweet, irrelevant and prejudicial. All right, so Manson's position, instead of providing sworn testimony from people with personal knowledge to support certain facts, instead of doing that, they cite 5 minutes worth of snippets from this inflammatory 2.5-hour film. So you got this 2.5-hour film and you just pull the 5 worst minutes out of context out of it and throw it in there. Lodged again with the court on a thumb drive. I like that it's lodged there. I have this book lodged on my desk. I feel like I should be smoking a pipe. No reason for the court to review the vast bulk of this film, let alone the portion cited by Ms. Wood. So they throw in this whole 2.5-hour thing while only using this 5 minutes worth. And they attempt to get it into this anti-slapp context by talking about how they were amassing evidence for ongoing criminal investigation of Manson, providing such evidence to law enforcement, compiling and organizing it in every way. Citing a snippet from the film stating it depicts Gore delivering the materials to the FBI office. But the film shows Miss Gore carrying unlabeled boxes in front of unmarked elevator doors at an unknown building on an unknown day. And I think the unknown is the part here. And Miss Gore did not provide sworn testimony regarding this topic. So she can't rely on this film or what her attorneys say about the film as a substitute for admissible evidence. Her attorneys have no personal knowledge of what this film depicts, and even if they did, they've offered no declarations themselves. And more stuff about what's on that film, including excerpts of the Dinner for Five thing, the meeting of survivors. These are improper as well. It's foundationless hearsay, not only of Miss Wood, but also third parties. Even characterizing this event depicted in the film as a meeting of survivors itself is hearsay without personal knowledge. Wood did not present sworn testimony from any of the people at such meeting. Her characterization and of the meeting and the contents of the meeting are inadmissible hearsay. The clip is incomplete. Wood is already submitting the transcript from the show. So there's that. And then the defendants come back and say, hey, notwithstanding the arguments made above, which almost exclusively concern Phoenix Rising itself, it concerns Wood's testimony authenticating Phoenix Rising and identifying the timestamps. Blah, blah, blah. They're saying again that Manson's chief objection is the use of the word survivors to describe the participants in the meeting. I don't know. I think it's a broader objection than that, but I also get what they're saying here. Yada, yada. Phoenix Rising itself is clearly relevant. And they make the point that portions of the complaint that defendants strike even reference Phoenix Rising and or defendants' involvement in it numerous times. And it was a forum to coordinate allegations filmed for Phoenix Rising. Is the allegation. Plaintiff's argument directed toward defendant Gore are also misplaced, if not frivolous. The documentary itself is admissible original writing that is the best evidence of its content. It's not prejudicial merely because it highlights similar accusations about plaintiff. Generally, it's harmful to his case. It's certainly not so prejudicial that it substantially outweighs its probative value, which is kind of normally the weighing function when you're dealing with prejudicial evidence, because all evidence that you want to submit is intended to be prejudicial against the other side. So it's undue prejudice is what you're talking about normally. It's a waste of the parties in the court's time, using the procedural tool of evidentiary objections to dispute the allegations of abuse. Ironically, his argument here exposes the reason he brought this lawsuit to chill the free speech about and participation in public discussions of sexual assault at the hands of a global celebrity in the public eye. And I'm reading this for the first time as you are, but I tend to key in more when the writing gets more novelesque. So there's probably lots of meritorious legal things that I'm overlooking, I'm sure. Objection number 4 is still Manson, objecting again to Wood Exhibit 4, the thumb drive lodged with the court with the HBO documentary. And he merely incorporates by reference his other arguments as stated above, which I'm thankful for that. And the defendants, however, carry on and with many arguments about how the video is relevant and it's not hearsay. I'll leave the mystery of whether it is or not to you to look more deeply into this text here. Objection 5, still, and remember there are only 18 of these things, so still Manson. Objecting to the Rolling Stone article entitled Marilyn Manson, the Monster Hiding in Plain Sight. If you're Manson's lawyer, you would probably object to an article entitled, My Client is a Monster Hiding in Plain Sight. Hearsay and hearsay within hearsay lacks personal knowledge. So Rolling Stone article is not admissible evidence of the countless prejudicial falsehoods it contains. Indeed, the article's subheading confirms it is mere hearsay. He was a provocative media darling for decades. Offstage, exes allege, he was an abuser who made their lives hell. A Rolling Stone investigation based on court documents and more than 55 new interviews. Ms. Wood has not submitted any testimony from any of the interviewees, and this article is not a replacement for that testimony. She doesn't say she has personal knowledge or hasn't established that in the allegations in the article. Wood cites the entire article and several civil complaints as evidence for the statement that many other women have also accused Warner of abuse. Warner has already admitted he's been accused of it falsely, parenthetical, and his complaint includes allegations to the same effect. Requiring the court review the entire hearsay article to establish the same point is prejudicial, and I would say being forced to read a Rolling Stone argument is a form of prejudice. Defendant's position. Plaintiff ignores that he put the Rolling Stone article at issue here when he cited in his own footnote. The complaint, what's up? Courts may, quote unquote, examine the exhibit the complaint incorporates and, quote, treat the pleader's allegations of its legal effect as surplusage, end quote. Courts will not close their eyes to situations where a complaint contains allegations of fact inconsistent with attached documents, bro. So plaintiff effectively waived his challenge to the Rolling Stone article when he put it in his own complaint. More arguments. Stories about plaintiff's conduct. Plaintiff is Manson throughout his career relevant to defendant's state of mind and whether defendants acted reasonably. Yippity dip to objection 6. And it switches over to defendants Wood and Gore. And they are moving to object to Blair Burke, part of her declaration. Hearsay and lacks foundation. And talking about whether the letter's a fraud, whether Manson was investigated. Defendant's position. So although the plaintiff agreed to withdraw several statements by Blair Burke about her conversations with FBI agent Michelle Langer, he's not withdrawing the statements listed above, even though they are clearly inadmissible hearsay. They're all out-of-court statements offered for the truth of the matter asserted. This is classic inadmissible hearsay, and no hearsay exception applies, the defendants argue. Indeed, when defendant Gore previously objected to the hearsay statements in Burke's declaration, Manson did not claim an exception applied, but rather argued that the objection can be cured by the deposition of Agent Langer that Warner already requested. I don't know whether he was going to be able to get that deposition, however, since she works for the FBI, that's kind of up to the government. Now, the defendants take that to mean that Manson conceded that Agent Langer's purported statements are hearsay. That may be taking it a little too far. When he's saying the objection could be cured, that's not necessarily conceding that it's meritorious, but I get what they're saying there, because their point is, hey, why did he need this deposition if he thought that the declaration was good enough? So I think they've got the better of that. And they say his newly amended argument that Agent Langer's purported statements qualify as spontaneous utterances under the evidence code is absurd. They cite a case where the California Supreme Court found the trial court abused its discretion by admitting as a spontaneous utterance a statement made by the victim where the statements were made in response to questioning, not blurted out, and when there was no evidence that the victim was excited or frightened when she spoke, or that her physical condition at the time of her statements precluded deliberation. No evidence that the statements were made under the stress of excitement. And then, let's see, Manson is basically taking the tact that, hey, you already looked at this and said we could use it, Judge. And then secondly, spontaneous utterance, which of course we knew was forecasted because they were rebutting that up above. Spontaneous utterance, I would say, is a fair description of how I answer most questions in a corporate setting, but that doesn't mean they qualify under the evidence code as such when they just sound that way. So I kind of see where the defendants are coming with this. It's kind of tough to think that an FBI agent talking on a telephone call about a single-page letter is under such stress of excitement that she's just blurting things out. The judge will have to decide whether that makes any sense or not. Objection 7, defendants Wood and Gore objecting to many exhibits and the supplemental exhibits to the supplemental declaration of Howard King. They lack foundation, lack personal knowledge, lack authentication, and they're hearsay. Let's see. Okay. So these are documents from the iPad, the gifted iPad. Plaintiff submitted a number of files that purportedly found on a broken iPad that Brighton Gore claims she received as a gift from defendant Gore. That's the sisters. And the Brighton ended up with the iPad, saying that it was a gift from Gore, Ilma Gore. Whether it was a gift or not, it does appear to be Ilma Gore's iPad that ended up with Brighton and now has ended up with Manson's team. Let's see. Established the files were on a broken iPad, but they don't have personal knowledge regarding the files themselves. No one has properly authenticated the purported files or laid a foundation for them. Who created it, when, why, and for what purpose? So yeah, I mean, hypothetically, let's say this text of this letter were on there. How do you know if Ilma Gore created it or someone else created it if no one's talking about that? I think is what they're saying here. You haven't authenticated the origin of it or even really what it is, a portion of a message, etc. Courts routinely find that communications proffered by someone other than a participant are properly excluded for lack of authentication, foundation, lack of personal knowledge. These kind of things to me are one of the problems with this whole anti-slapp thing, because these are very technical arguments over the evidence, and anti-slapp should just be really to test whether you have a case or not, whatever. It seems like something you normally would do later in a case, but that's just not how it is happening here. Screenshots of images, still shots of videos, web pages. King's supplemental declaration does not even attempt to provide foundation or context for these purported screenshots, or could he? King doesn't claim to have personal knowledge of who took the screenshots, when they were taken, why, etc. And because nobody's done that, get this stuff out of here. It's just garbage. Let's see. Now, Manson says the 14 exhibits are documents found on the iPad that belong to defendant Gore. The objections are meritless. Plaintiff has offered evidence explaining in detail what the documents are and how they were collected. There's no dispute that the files were on the broken iPad that Brighton Gore received from defendant Ilma Gore. No dispute. And they had an IT consultant look at it. Explained that he met with Brighton Gore and conducted an industry standard analysis of the iPad, including copying device and associated file level metadata. Provided that to Manson's counsel. Instead, defendants appear to argue that Ms. Gore is the only person who can explain what the documents mean, and since she hasn't done so, they're inadmissible. That's wrong, especially in any SLAPP context where the plaintiff's prohibited by statute from taking any depositions. Yeah, that's kind of my point. When you get down to this kind of technical level, is that really what you should be doing at the anti-SLAPP level? Bootstrap, nice word. Competing evidence, controlling authority. Defendants misunderstand the difference in an anti-SLAPP proceeding where discovery is limited, and I am sure what is normal civil litigation. Defendants deny and cannot show based on their objections that documents could never be introduced at trial. If you were to accept the defendant's argument, you would turn well-established doctrine on its head. Because discovery stayed, so some of these things they can't do at the early level, even if they have this kind of forward-looking evidence like the pictures from the iPad, they can't go back to all the foundation if they're not allowed to pull anything up about that. Wow, this video is getting very long. Some of you asked for it. It's your own fault. Objection number 8, defendants Wood and Gore. They want to strike parts of Bright and Gore's declaration and Exhibit A to the declaration. They say it lacks foundation, personal knowledge, authentication, and it's hearsay. Of course, this is the Alabama thing with some text of this purported FBI letter. What you think? It's good. I don't know about the letter stating the arrest before it happens. Defendant's position. Why should this be gone? The purported quote-unquote screenshot that Brighton claims to have seen on the broken iPad. She doesn't have personal knowledge of the purported screenshot that she describes and offers as Exhibit A. She speculates that the screenshot depicts a partial text conversation on the Signal app between Wood and Ilma, which purportedly occurred in November 2020. She does not claim that she took the screenshot of the purported text conversation. She doesn't claim that she participated in the purported text conversation. Next time I get a text from my wife, I'm going to answer it by saying, I cannot say about this purported text conversation. Because she doesn't claim personal knowledge of the purported communication at issue, she can't authenticate the document or lay a foundation for its admission into evidence. Moreover, the document described as a screenshot does not actually appear to be a screenshot at all, but rather appears to be a photograph taken of the iPad itself because the broken screen is visible and there's a reflection in the top right corner of the image. That certainly appears correct to me as well. In other words, it wasn't something pulled off the iPad and put into evidence. It's a picture of the iPad screen. That's how it's looked to me since I've seen it. There's no foundation laid for who took the photograph, when, and for what purpose. All right. Now, they cite cases that they think substantiate their objections. It's only a partial part of it. Sustain the objection. What does Manson say? It boils down to a competing interpretation of evidence disguised as an objection to admissibility. Competing interpretation of evidence disguised as objection to admissibility. So, how you see the evidence, Your Honor, is not a reason for it not to be admissible. There are no issues with foundation or personal knowledge. She merely explains that she received an iPad from her sister and explains what she saw on the same iPad. She quoted those materials verbatim and attached them as exhibits. They say this is so absurd that this would be just like a witness not being allowed to testify about a car wreck, the color of the car involved in it, because they were not driving the car at the time. I don't know if it's exactly like that, but that, lawyers love analogies, and I like that one. The hearsay objection lacks merit. Merely repeats what defendant Gore told her or other statements by defendants. I don't know. Okay, let's see if it's something about the photograph, though, because that's kind of cool. Bright and Gore testifies that that image is a true and accurate copy of what she saw on the screen in the very testimony they seek to exclude. Neither defendant actually contends the image is inaccurate in any regard, nor is there any basis to dispute that the underlying image is a screenshot. The top portion of the image shows the date and battery life as appears on the screen of an iPad or iPhone. Yep. And then a hypertext link so you can get some support for your Apple iPad. While it would be needless multiplication of the record, plaintiff would be willing to submit the underlying document copied directly from the iPad. It just wouldn't have the cracks on it, which ironically confirmed authenticity. Objection 9. Defendants Wood and Gore, some more Bright and Gore stuff, and foundation, personal knowledge, authentication. This was the letter, the famous letter Is it real? Is it fake? Who made it? What did he use it for? Who knows? Defendant's position. The above excerpts of the declaration describe the purported screenshot that Brighton claims to have seen on the broken iPad that has to do with this FBI letter. It's in personal knowledge, so we get kind of repetitive here what this stuff is. Plaintiff has previously argued that the fact that an image of the FBI letter purportedly appears on a broken iPad somehow supports its speculative and, parenthetically, incorrect theory that the FBI letter was used to recruit women to accuse plaintiff of misconduct. Not so. There's no evidence that the FBI letter was used to recruit anyone or that any of plaintiff's accusers received a copy of the letter. So they're wisely hearkening back here to what the judge has said before. Hey, can you show me where this was actually used against you by people involved in this circle of conspiracy that you're talking about? As if you can, I don't know that I see the point of it. So they're bringing that back up, which is a good idea because the letter looks bad. No evidence contradicting Wood's unequivocal testimony she did not distribute the FBI letter outside of the scope of the custody dispute. I'm going to go off to the side here for a minute and say that while I know everybody has a theory about the letter, I've developed my own based on Wood's declaration in this current lawsuit. And assuming that it's truthful, her attorneys would not let her willfully and nor them participate in perjury in this current lawsuit. I take that as a given and reconcile that with how she characterized the letter in her earlier filing in the custody dispute, harmonize those together and come up with an idea of where this letter came from and how she got it. I certainly have a theory on that. It doesn't require her to be a liar in her declaration, which her lawyers would not want or allow her to be if they knew about it, but instead is a truthful account. It doesn't make this letter good or good for the defendant's case, but anyway, I have my own theory on that. Let's go. Manson's position. Defendants apparently contend that Brighton Gore cannot testify as what she saw on the iPad, so we're kind of, in the same argument there. Objection 10, defendants Wood and Gore. Declaration of Brighton Gore. And I have part of a purported text conversation occurring there, sorry. Paragraph 20 of the declaration says, another thing I saw on the broken iPad were 2 images of the checklist. So, all right, I'm going to blow past this because, this is all going to all be kind of the same stuff. Objection 11, defendants Wood and Gore. And this is to Brighton Gore's declaration. Saw emails and draft emails purportedly written and or sent by me, which I never drafted or authorized. Okay. And other things relating to Wood, Phoenix Act, etc. Inadmissible hearsay, all this stuff, they say, the defendants. And she didn't attach any of these files. She purports to describe her testimony as inadmissible to prove the contents of those files. Yeah, it's kind of got, if she has this iPad, which she does have, wouldn't you think there'd be more on it than just a few screenshots that people did see? Probably so, and this is some of the stuff, but it wasn't attached actually to anything. So really, what should you draw from her description of what she saw if she didn't bother to attach it? I kind of see what they're saying there. But Manson said, look, this is just background and introduction, okay? And then we detail the things that are more particularly necessary. And they say, come on, bro. This is unclear how your objection complies with the court's order of December 1st, that only objections that should remain are those pertain to material evidence regarding material issues. So they think this just is not even an important objection. Objection 12, defendants Wood and Gore. More about Brighton Gore, lacks foundation, improper lay opinion, and irrelevant. So this is where Brighton's given her opinion about the similarity of the various signatures, etc. And I'm sure they're going to say, look, she can't be giving her opinion about who's signed what. Lack of foundation based on when she actually got this broken thing working. And Brighton does not claim to be a handwriting expert, nor does she claim familiarity with the handwriting of the person who signed Exhibit C. testimony that two signatures that she purportedly saw several months apart are the same. That lacks foundations in admissible lay opinion. So, when you're trying to conclude a fact, letting somebody give an opinion as to the fact, it's not something you let a lay person do. That's what an expert's supposed to do. Then Manson says this objection is immaterial because the court can compare the signatures itself. But it lacks merit because she's testifying about what she saw. She said she saw her transfer a signature from one document to another, which that is a totally different thing than comparing them. And then she says it appears to be the same as the one she saw before. And that's not really a handwriting analysis. That's saying I saw an image of something, and I think this other image was the same. So I hear that too. Opinion testimony is admissible when rationally based on the perception of the witness, right? So they're not using training and things. And she's not trying to be a handwriting expert. She's saying this image is the same as this other image, I think. Take it for what it's worth. So, And so they say, hey, look, this is no material objection, okay? Objection 13, defendants Wood and Gore. More Bright and Gore excitement. Through the items that were left in the garage. Unorganized, crumpled stacks of papers and trash. True and accurate copy of something that was in her sister's handwriting. Notebook, etc. So they're saying that, hey, saying this looks like her handwriting that lacks foundations, improper lay opinion. Haven't laid a foundation of what they are, etc. So this is going to be real similar to the last one. Lay non-expert witnesses, lay witnesses can state their opinion whether a writing is in the handwriting of a supposed writer. I mean, she's seen her sister's handwriting a bunch. I don't know why she can't say, I think that's my sister's handwriting. She may testify that she, parenthetically, unsurprisingly, recognized this handwriting found among materials left at the house as belonging to her identical twin sister. So forth and so on. Objection 14, Wood and Gore. And that is, over the years, Ilma shared her iCloud credentials with me so that I could use her account on Apple devices. I opened the iPad with these credentials once it was powered up so I could use it. That's objected to. She can't testify as to Ilma Gore's state of mind, including why she shared her iCloud credentials. Let's see. So Manson says, hey, she's saying what defendant Gore shared with her, the credentials. She has personal knowledge. It's not hearsay. She's not purporting to relate to another person's state of mind. Whatever. Objection 15, defendants Wood and Gore. More Bright and Gore excitement. This is when she said, I told Wood I saw the FBI agent letter a year earlier. I saw my doctorate, et cetera, et cetera. I was shocked at the response, all that. Lots of similar objections again about lay opinion, improper legal conclusion, hearsay, et cetera. Bright and Gore's recounting of her own out-of-court statements to Wood is hearsay and cannot be offered for the truth of the matter asserted. Wood's statements are also hearsay to the extent they're being offered for the truth of the matter asserted in opposing the motion. They're saying the doctoring lacks foundation regarding what she actually saw, and it's irrelevant. Because this letter, whatever it is, existed months before April or May of 2021. Wood testified she used it in March of 2021. So she's not laid any foundations for the documents she saw in April or May of 2021 being that document. And her testimony, she knew it was fake or doctored or whatever, is inadmissible lay opinion. Manson says this has already been looked at and overruled by the court. And further, statements of a party here admitted against the party are not hearsay. Objection 16, and that is to things that Manson himself says, and also Paula Weiss. That deals with the subject of what Groupie was about. He says it was a professional art/horror film. Yeah, I don't doubt some of that. The actress was over 21. That's also in his statement. And more about that. And then the declaration of Paula Weiss. the things that she said about it. And it's pretty simple. Obviously, she's of age while she was in the film. Overage would be me. Defendant's position, all of the testimony set forth above describes the contents of the film Groupie, but plaintiff has refused to produce and submit a copy of it. All this testimony is therefore inadmissible under the secondary evidence rule. In other words, the best evidence of what's in the video is not people talking about what they saw in the video, but the video. Plaintiff must show the statements about Groupie are false as part of his defamation and IIED claims. Defendants argued at the earlier hearing the plaintiff could not prove the contents of his Groupie film through testimony alone, and he couldn't demonstrate the statements about Groupie were false, therefore, without submitting the video itself, which has not been done. He doesn't claim he doesn't have access to the video, but he failed to submit a copy of it. When meeting and conferring about this, so this is new information, defendants again raised this issue and inquired whether plaintiff Manson would produce the Groupie video and file a copy with the court. He declined to produce or submit a copy of this video. So they're saying that if he makes the choice to not produce the video, which he hasn't said he doesn't have, then he can't substitute for that video as evidence, people talking about what the video is, because the best evidence of the video is the video. And then they forecast what Manson's response will be, that it's undisputed that Weiss appeared in the film, and court already overruled secondary evidence objection. Neither argument withstands scrutiny, they say. Yeah, there's a lot of nasty things about what's in this film and how they distinguish it from earlier rulings. The court did say, how would you determine the identity of the actress and Groupie if the video were submitted? And defendants say, well, if you were able to see the video, you would at least know whether some of these allegations are true or not. But as a practical matter, if he had submitted a copy of the video and then the declaration of Weiss that I'm the person in it, there'd be no secondary evidence rule objection. But that's not what happened. He refuses to submit it despite multiple opportunities to do so. It speaks volumes and renders the testimony about its contents inadmissible under Section 1523. And I think if you're, a pro-Manson person, you have to respect this argument that if you're not willing to show what was in the video, then should we really allow you to substantiate your position about what's in it by talking about what's in it? That is a poorer form of evidence when you have the better form of evidence about it. Oh, I have a confession in writing right here. Let me read it to you. Well, no, show it to me. No, I'll just read it to you. Just trust me. It's what it says. You really wouldn't like that either, right? So I get what they're saying here. Defendant's insistence that Groupie be admitted as a precondition to testimony about the casting or creation of the film, which has already been rejected by the court, is a transparent attempt to sway the court on the merits by forcing it to watch a shocking, parenthetical, although staged, horror film. This is Manson's response. So they're saying, look, this is just a shocking horror film, and what's the point? Defendants have no evidence that Weiss was not the actress at Groupie. She testified under oath she was the actress. I mean, to me, that seems fair on that point about who was in it. She testified she's in it. I don't think that necessarily excludes who else was in it, though, however, because he hasn't shown the video. Defendant's contention that the court must watch it to validate the testimony of the actress and filmmaker is nonsense. There's zero evidence to the contrary. Accordingly, the court was correct when it rebuffed this argument for the first time, pointedly questioning defense counsel as follows. The court: well, just out of curiosity, if I looked at the video, what did you think I was going to do with it? Attorney for a defendant: I'm sorry, the court: if they had produced the video, Manson, and I played it, how do you think that would play out? I'm supposed to conclude who's in the video? While defendants now suggest that reviewing the video would permit the court to do While defendants now suggest what reviewing the video would permit the court to do, conspicuously absent from the list is determining the identity or age of the actress, which of course is what's material here. This video is insane, but this is over 60 pages of stuff. Sorry for the length. And lots of cases relied on, etc. Objection 17. this is more objections to Manson's declaration, foundation, personal knowledge. This is about the groupie thing. And then that this is a long-running conspiracy. I've been defamed, impersonated, hacked, and swatted. These excerpts of plaintiff's testimony purport to describe conduct of Wood and Gore, even though he doesn't claim to have witnessed this conduct. It's inadmissible because he doesn't have the requisite personal knowledge or foundation to offer it. Manson doesn't claim to have witnessed any alleged defamatory statement about Groupie. Defendant's purported conspiracy to cast him as an abuser. Defendant's interactions with women who made the accusations against him, or any alleged impersonation, hacking, or swatting. Nor does plaintiff have foundation to testify regarding defendant's motivation or state of mind. He cannot testify to his own self-serving conclusions. They merely restate the allegations in his complaint. And that seems fair. It's an allegation in the complaint. It's certainly his vision of how things occurred, but does his vision establish the facts of what occurred? Let's see what they're saying. Numerous improper lay opinions and legal conclusions and arguments. All right. What does Manson say? It's already been overruled, bro, for parts of it. No explanation for taking a second bite at the apple, hoping for a different result. Also, these paragraphs are not being offered as conclusory evidence of liability, as defendants suggest. Defendant Gore committed defamation because Mr. Warner says she defamed him. This is mere introduction and background to the remainder of the paragraphs that contain his description of the harm he suffered. And notice they don't object to that. This is not a material objection. Objection 18, ladies and gentlemen, and this is regarding the declaration of Michelle Meyer, objected to by defendants Wood and Gore. Foundation, personal knowledge, improper lay opinion, inadmissible legal conclusion. I am also a victim of Ashley Gore and Evan Rachel Wood's unauthorized and illegal use of my phone number on a forged FBI letter. I was shocked that she had apparently either given my phone number to Holly and Bell or given my phone number to Wood, who then gave my number to Holly and Bell and likely told them that this number belonged to Michelle Langer. Blah, blah, blah. Yippity-dit. Illegal use of it. Defendant's position. These excerpts of Meyer's testimony, they describe conduct of Wood and Gore that she does not claim to have witnessed. She didn't witness it. She doesn't have firsthand knowledge. It's inadmissible. She doesn't have the foundation to testify regarding the conduct of others who put what number on what. She didn't see that happen. It's clear from her own testimony she's speculating or guessing about what they did. Apparently. Likely. I have no idea to what extent. Numerous improper lay opinions and improper legal conclusions. That is a summary of social media. She has no personal knowledge or foundation. Oh, transparent copyright. Plaintiff's position, Manson. They're not offered for the truth of the matter asserted. Well, that's a good one out of the gate because that's what hearsay is. It has to be something offered, out of court statement offered for the truth of the matter asserted. The declarant is explaining her state of mind at given points in time and what she believed informed certain of her actions. Many of the objected to fragments are phrases that modify or contextualize other parts of the same sentence describing some action by Ms. Meyer, portions to which defendants do not object. These are all just background or context. They've not been quoted or relied on in the opposition. And so it's not a material objection to the evidence regarding material issues. So there you have it, a long and boring set of consolidated points by the parties, but that is good. It's good for them to have done that. So they obviously communicated a lot on this, and they presented the court with the 18 remaining objections, the basis for the objections, the court can sustain or overrule, and a quick summary for each point of the positions of the various parties. So they have done a lot, I think, that the judge asked them to do on both sides. While there's some argument in there, it looks to me like everybody participated in good faith to do what the judge asked them to do. And the judge can make a ruling on all this. However, it may relate to her later decision on the motion On the anti-slapp, I don't know. I don't really think it does, but we'll see. So that's what all these filings are about. It's not a giant conspiracy. It's just the parties doing what was requested by the court prior to the anti-slapp motions being heard. Thanks, bye.